Let me welcome everyone to this 18th Young Scholar Lecture sponsored by the Wallace Stegner Center for Land Resources and the Environment here at the S.J. Quinney College of Law. I'm Bob Kiter. I have the privilege of serving as the director of the Wallace Stegner Center, and it's my pleasure to introduce our speaker today. The lecture is hybrid. We have several people in the room here at the law school. We thank you for your in-person attendance. We're trying to, if you will, rebuild the notion of in-person attendance. And we also have more than 200 people online, according to our registration figures for this event. Let me begin with our native lands acknowledgement. We acknowledge that this land, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. A few announcements about future events at the Stegner Center in conjunction with the Global Change and Sustainability Center at the University of Utah. Next Tuesday, November 1st, over this noon hour, we will be hosting a presentation by Brenda Mallory, the 12th chair of the White House Council on Environmental Quality. This is a pre-recorded presentation that airs between 12:15 and 1:15. Registration is required online at the Stegner Center website. There will be an opportunity for some Q&A after the presentation. And then next week also, our events seem to be bunched this time. We will host for another Wallace Stegner Center Green Bag on November 3rd, next week. Distinguished Professor Emeritus at the University of California Hastings College of Law and former solicitor, that is General Counsel for the Interior Department during the Clinton administration, Professor John Leshy, who will speak about his recently published book, which is a comprehensive history of the public lands. The book is entitled Our Common Ground, A History of America's Public Lands. And then next semester, March 16th and 17th, Stegner Center is very pleased to present our 28th annual symposium on the future of the Great Salt Lake. The title, I think, expresses what the topic of the symposium is. There's very few issues that are more concern to us here along the Wasatch Front than the future of the lake, given the tremendous drop in water levels and all the environmental implications that attach to that. So again, next spring, our 28th annual symposium. All of these events you can get more information about by going online on the Stegner Center website and hitting the calendar of events button there. The Young Scholars Program for the Stegner Center is designed to recognize and establish a relationship with promising scholars early in their academic careers. Recipients of this are selected based on their accomplishments, the quality of their academic work, and their promise in the field of environmental and natural resources law and policy. This Young Scholars program was founded in 2005 with the generous support of the Cultural Vision Fund, which continues to be the primary supporter of this program. This year, for our 18th annual Stegner Center Young Scholar Lecture, we will hear from Professor Vanessa Casado Pérez, who is not only professor, but also the Dean's Research Chair at Texas A&M School of Law, and she is also a Research Associate Professor at Texas A&M's Department of Agricultural Economics. In addition, her work scholarship focuses on property and natural resources law. She was the Pace Haub Environmental Law 2021-22 Distinguished Junior Scholar. Her research has been published widely and includes publication in such journals as the NYU Law Review, Northwestern Law Review, the Iowa Law Review, and the University of Southern California Law Review. The topic of her talk today, as you're well aware, water markets, the good, the bad, and the ugly, which addresses the recent developments in the area of water marketing. She will talk about some of the arrangements that have emerged in this field. That includes the trading of water futures in the Chicago Mercantile Exchange and the investment by Wall Street firms in irrigation mutuals in Colorado. Basically, the underlying question is the good, the bad, and the ugly about commodifying this valuable resource, and she will share observations about these various arrangements, which ones seem to work, which ones seem not to. As for the question and answer session at the conclusion of her talk, to ask those questions either from a remote location or here in person, just follow the instructions on the screen. And if you like a question that someone has posed, just click thumbs up next to that question and it will rise to the top of the list. With that, please join me in welcoming our 18th annual Young Scholar to the Stegner Center and the College of Law, Professor Vanessa Casado Pérez.
Let me start with the conventional thank yous, not because they are conventional or less felt. I thank the Stegner Center for the invitation. When I received the phone call and the email from Bob Keiter this summer, I was both pleased and surprised. The previous Young Scholars are people that I very much look up to. And it's a great honor to deliver this 18th annual lecture, but it's also a great opportunity to engage with an amazing environmental law faculty. And with further ado, let me start introducing my topic. I'm going to talk about water markets as a tool to introduce flexibility in water allocations in times of scarcity. I believe water markets are a tool in the hands of public agencies, so they are not free markets. And I believe we can constrain them to serve values other than efficiency, or at least not allow them to step on those values. Just to offer you a roadmap of how I'm going to organize this talk, I first will explain a little bit the current situation of scarcity, what is the general view of what water markets can do. I will then move to analyze which roles government needs to play for water markets to actually work. From a purely neoclassical view, right? There is a market failure, the government needs to fix it. And then I will move on to the critiques of water markets and what have we done to address them, or what could we do. Among these critiques, I will focus most of my time in the speculation critique. This whole idea of Wall Street investing in water and how some states are starting to take some steps in order to prevent that from happening, or at least to rein them in. I have to start by apologizing to water lawyers in the room, because I may explain some basic principles to make sure that everybody can follow along, and also because, as it always happens when you talk about prior appropriation in general, you are talking about the law of nowhere, because there are nuances in every of the states that are covered by a prior appropriation regime. So water scarcity is, let me see, the slides are just, pictures to make sure that you know what I am talking about. Water scarcity is a phenomenon that it's currently getting worse. Due to climate change, droughts are longer, more intense, and more frequent. We have less precipitation and higher temperatures. But that not only affects the supply side of the equation, it also affects the demand side. If it rains less, we are gonna have to irrigate more, particularly if temperatures go up. So it's very likely that we will see more conflict between different uses and between different users. Competition for scarce resources is nothing new. What has changed is that's the new normal. We have always had situations of over-allocation. But the new normal is we are not going to have enough water to satisfy everyone that has a demand for water. And we have to decide how we are going to allocate, in times of scarcity, whatever few supplies we have. Just to illustrate this idea of the new normal, California is planning for a future with fewer water supplies. They estimate that their supplies will shrink by 10%, but that's not a prediction for a distant future. They are planning for 10% less in 2040, which may seem a long time from now, but it's actually around the corner. Our predictions tend to be, always far along. To respond to this global problem, different jurisdictions have adopted strategies of increasing supplies. Right? Desalination, water reuse, recycling the water that we otherwise would return to the river. But also measures on the demand side, trying to increase efficiency, making sure that farmers use drip irrigation instead of flood irrigation, making sure that all of our appliances are water efficient. But even if, and in fact, even though population has increased, our consumption per capita seems to be going down. But even if we take all these measures, it's the truth that we are not going to have enough supply, so that we will have to come up with a strategy to decide how to allocate it. And this is true in the American West. We have heard about, the current situation, but it's also true everywhere. Right? Now we see tensions between Mississippi and Tennessee, tensions between Georgia and Florida, in areas that before were areas where water was not an issue. I'm going to focus more on the US West because it's suffering what we know as a mega drought, right? We are in what they call this 22 years of drought, which is the worst since 1200. And Utah, as you can tell, is not doing very well. Probably not as worse as California, but it's something that I am sure is on your minds. When we are faced with the situation of mismatch between supply and demand, prior appropriation, which is the system of the West, everything crossed by the 100 meridian line or west of that line, so if you take a line from the middle of Texas up to Canada, everything crossed by that line or west would be a prior appropriation state, has an answer to the question. All the rights should be satisfied first. That means we don't care if the older right is less valuable than a junior one, we allocate using this priority date. It's a very clean rule. Other jurisdictions have different approaches. Australia gives you a percentage, right? Decides which percentage of your right will be allocated across the board, a pro rata reduction. Other jurisdictions, such as Spain, I am from Barcelona, there is a ranking of uses where domestic uses will always be satisfied first, and then below those, every basing organization has the right to choose which is the least. Most basing organizations have chosen agriculture on the second place based on the premise that agriculture doesn't have a good substitute for such a production input, while in other types of activities you may have one. I am actually curious about, and I think I understand it in the following way. There is a reform of the Utah Water Code that it's going to go in force in 2023. And if I read correctly, the situation is that you're going to set aside priority dates in order to satisfy some preferential uses, those being domestic, basic needs, and fire suppression. And I think in a second place, agriculture is also playing a role, but where if your preferential use is satisfied, you will have to pay whoever is not receiving the water. So it's almost a forced market transaction with an analysis of who has a higher value. Maybe not a monetary higher value, but a higher value as we understand it. Whatever the method, all these rules of apportionment are rather crude. We don't know who values the water most. And markets are precisely here to introduce flexibility. Someone may be in a better place not using that water and selling to someone else. But even if we think about those water markets, the truth is they are not going to be the main allocation mechanism. So it's important to understand that we are not going to displace the current allocation mechanism by allowing some trading. At most, the volume traded in what we consider active water markets, and this is California, tends to be between 2 and 4% of the overall water use. But even that, it's worth to engage in because it allows for some flexibility. I talk about water markets as the exchange of water rights, be it via a lease or via a sale. But water market is an umbrella term. And you may hear things regarding water markets that refer to bottled water, that refer to water futures, that may refer to the privatization of water utilities, and that may even refer to land transactions. Because often when we transfer land, what we're really interested in is the transfer of the water rights associated to that land. Defendants and detractors of water markets tend to have very polarized positions and often lump all these water markets together. Let me put these two positions in perspective and then try to explain where my analysis fits. We have pro-market, the free market environmentalists that believe that agencies shouldn't be the ones allocating water. Because one, they don't have enough local information to know where the water really should go and who will put it to a better use. And two, because they are subject to make decisions influenced by public interest groups. And they illustrate that by saying, we are receiving water incredibly subsidized. Nobody prices water. At most, you pay your transportation costs. So if you are not paying the true value of water, you are not going to have any incentive to use water efficiently. On the other side of the spectrum are those who think that water markets are abnormal. Right? Our constitutions recognize water as public property. And as such, we shouldn't allow anyone to profit from water. That's, they, I would say, are not necessarily or not only against the institution of water markets, but even against the institution of private usufructuary rights. Right? Like they dislike this idea that private interests could have control over a resource that we recognize belongs to us all. And maybe, you will see these critiques or these both positions better with an example. Coalinga is a city in California. It used to receive 3,500 acre-feet a year from a Bureau of Reclamation project, from a federal project. They normally pay around $190 per acre-foot on normal years. There has not been a normal year in a very long time. So they hardly ever receive 3,500, which was their normal allocation. But increasingly, they are receiving less and less. So they know that in order to supply enough water to their residents and to the business in the locality, they need to buy water. Water in the open market is around $2,500 per acre-foot. And that seems like a very steep increase in price. However, once you break it down, the situation seems slightly different. So if we think that every resident needs 208 liters per day, that's what we need to cover our basic needs. That's about 42 cents at the $2,500 per acre feet. 42 cents amounts to $13 a month. That can actually be steep for a family, for a low-income family. But that implies only around 1,000 acre-foot. We could clearly subsidize 1,000 acre-foot. It's the other 2,500 that we have to decide what is the best method to allocate. Right? What really is at stake is whether the city of Coalinga should continue providing subsidized water to the agricultural sector or to other businesses. Right? We could clearly protect the amount of water that we need for basic needs. But I stay away of both the pro-market or which believe in a free market and those who completely ignore markets. And I see, as I mentioned at the beginning, water markets as a tool for the agency administering and governing water to use in order to introduce flexibility. And even if we will introduce some flexibility in how we transfer water, I don't imagine going much beyond that 4% of illustrated in these graphs. Why? In part because water is local and it's very expensive to transport. So another example to illustrate this point, Devon Pickens, an oil baron from Oklahoma, but well known for the amount of oil that he traded in Texas, decided that the commodity he should be focused on was water. His company, Mesa Water, started buying groundwater rights in the Panhandle in Texas. They bought around 65 billion gallons, making that company the largest owner of water in the United States. The idea that Devon Pickens had was that they will sell that water to the growing Texan cities, mostly the DFW area, because it is expected to double the population in the next decade, or something, a projection along those lines. He managed to secure approvals for using eminent domain in order to build a pipeline. It turns out that he never built it because the DFW area was not interested in groundwater from the Panhandle because it was too expensive. They had other sources in order to increase supply, mainly investing in water reuse in recycling the water that they were already using. Devon Pickens still made a lot of money, but not as much as he predicted by selling it to the city of Amarillo, which is much closer to where his water rights were located. In addition to this idea of water markets being local, it's important to understand that buying water will never be like buying a pair of shoes. Right? Water uses are interconnected, and there are a lot of effects whenever we move water from one use to another. That implies that it will never be the one-click Amazon transaction. Maybe those should also be subject to approval, but the idea is that water markets require government to be involved. And I have classified the roles that government needs to play in a water market from the perspective of there is a market failure, we need to fix it, which I don't think exhausts all the roles that government needs to play, as we will see when we engage with the critiques. But those roles are, first, it defines water rights. Property rights are in themselves a public good. Someone needs to figure out how to define, needs to enforce those property rights, and the person or the body that does that, it's the governmental institution. One reform that governments could take in order to enhance water markets is to define what can you transfer. We know that you can divert a certain amount, and our water rights are defined according to that. But often we divert a certain amount, but that's not the amount we consume. Think about a field where I am irrigating. I divert a certain amount from the river, but I don't consume all of it. Part of it goes back to the stream. That return flow may be used and reused again by users that are downstream of my field. That implies that if I am allowed suddenly to transfer everything that I divert and someone else will transfer it in another point, the potential externalities are much higher than if instead I define the amount I can transfer as the amount that I have been traditionally consumed. I am not saying that there will not be externalities then, but they will be much lower. So maybe our review of water transactions could also be more streamlined. So in addition to defining rights, the government needs to ensure that externalities to the environment and to other users are internalized. How does the government traditionally do that? Through a review process. Those review process will have different standards regarding public interest and whatnot, but are supposed to ensure that the transaction will not have negative externalities, and if there are some, they are mitigated. But those processes are very demanding. It can take up to 2 years in some jurisdictions to get a transaction approved. Most jurisdictions now have a double track. So if you are doing a lease, that it's a short-term transactions to normally respond to an imminent situation, you'll have a less demanding review process with the view that at the end of the day, whatever effect you create, it's probably gonna be short-lived. But just to give you a sense of how complex a water transaction can be, this is it's still more or less the same. An old map that the State Water Resource Control Board of California put together in order to help water users understand what approvals they have to go through. They had to get an approval for the transaction itself. They may have to go through the state NEPA, the California Environmental Quality Act. They may have even more demanding inquiry if they are gonna pass through the delta of the Sacramento and San Joaquin rivers, because that delta has lots of pipes and lots of endangered species. I may talk a little bit more about this later. But it's an extremely demanding process, and it's more demanding if you are thinking about a permanent transaction than a short-term one. So defining property rights, ensuring that externalities are internalized. There is also a role about infrastructure. So we normally don't have a problem with infrastructure in water because we have natural pipelines called rivers. However, in many jurisdictions in the West, mostly through federal projects, but also state and private projects, deliver water to certain locations that otherwise will not have access to the amount of supply that they need. In the same way that we have opened the electricity market, the natural gas market, or the telephone market, where the only thing that it's really a monopoly is the infrastructure itself, the cables, but we should allow any provider to use those cables. The same is true in water. So, for example, if the city of LA or the city of San Diego want to buy water rights, their connections are managed by the Metropolitan Water District, which is also one of their suppliers. If they want to buy water from somewhere else, they should be allowed to use, for a reasonable tariff that is not discriminatory, to use the same infrastructure. So, defining property rights, internalizing externalities, open up infrastructure, and finally, a role that it's hard to define, but I call it the market maker. And that implies giving information about the market in order to label the playing field. So what type of information are we talking about? Are we talking about water registries? We are talking about price and transaction information. It's incredibly difficult to find transaction information in the West. And most of the databases are privately run. That means it may create inequality, or the playing field may not be level between sophisticated actors like this Wall Street type that I will talk later on, and an individual farmer. This is actually a reform that Australia is undertaking at the moment, because Australia had, made through that adage of not let a good crisis go to waste. They had a terrible drought in the beginning of the 2000s, and they started to reform or to redo, if you want, from scratch almost, their water rights system, with the idea that markets will be a huge component of it. And it has worked reasonably well, but one of the issues, apart from some corruption, but that's inevitable in any system to an extent, or it has nothing to do with which structure you are using, in this case a market, one of the problems they have had is this difference in sophistication and how certain actors have profited from their position compared to these individual farmer or indigenous communities. But again, these 4 roles are just based on the idea of correcting market failures. There are other roles that government can play in water markets if we want them to serve other values. That may come at a cost for efficiency, but I still think water markets will move us towards a more efficient water allocation. And I'm gonna distill them based on the different critiques. I would say there are 4 critiques regarding water markets. One is the effect on access to water. Will people have enough water to survive? The second one is regarding the environment. Are water markets going to ignore the environment? The third one is the effects on communities. Basically, if a lot of water leaves a community, what will happen to that area? And the fourth one is the speculation one. Wall Street is investing. Should we do something about it, or there is no difference than any other type of transaction we have had in the past? As I hope the Coalinga example illustrates, the critique about the human right to water, which, as we know, the US doesn't officially recognize, only some states do, the basic needs are a very tiny fraction of the amount of water that we need. One way we have been trying to be coherent with this idea of basic needs or human right to water in many jurisdictions is the tire tariff, right? Where you pay very little for the first gallons of water that you use in your household, with the idea that those cover your cooking, your cleaning, but not filling your pool or irrigating your lawn where you shouldn't have a lawn in the first place. So for those other liters, you will pay more. Right? So it makes no sense why we would exclude markets just based on the idea that may affect our base or the provision of our basic needs. Right? We could even give them for free and still allocate the other 95% of water that we use across the United States based on market mechanisms. The second critique is related to the environment. Will markets ignore the environment? And in theory, they shouldn't, right? On paper, we have a review that looks precisely at whether there are effects to third parties, but also to the environment. If those reviews are not well done, it's a completely different story, right? We should see how we can improve them. Another issue that comes to mind when we think about water and the environment, or water markets and the environment, is how we have used water markets to precisely provide for environmental uses. So traditionally, in private appropriation states, and I am sure if you have taken water law, you know this, the use has to be a beneficial use for you to have a water right. Beneficial uses were traditionally consumptive uses. We have expanded almost in every state that definition to encompass in-stream flows. So water that now you can leave it in the stream. Who can hold that water right depends on the different states, right? So in some states, it's only a public agency. In others, like in Utah, some nonprofit organizations or private entities may be allowed to. I think Utah changed that in around 2003. But the idea is that now those who care about the environment can not only lobby for in-stream flows, but pay for water rights and retire those water rights. And there are different arrangements. So in some cases, what has happened is that the government enters, like I think Oregon has done a good job at that, in some contracts with irrigators to improve efficiency and to subsidize those improvements. And in exchange, those irrigators have to leave a percentage of that conserved water to provide for, in-stream flows. And I think it's interesting because some studies suggest that in-stream flows don't work well always. But certainly they work less well when we have a drought, because agencies tend to be less keen on enforcing them when we don't have enough water to go around for other uses that may be more vocal than environmental ones. I think it's particularly interesting the way Utah approached this idea of donating water from stream flows, connecting it with enforcement of with the Endangered Species Act. So a lot of the donations seem to be connected to candidate conservation agreements with assurances. The idea is if you donate water now in order to protect the stream flow, if at some point the species that now may be, not in the best shape, but not yet endangered or threatened, you may have the assurance that we will not be too demanding on what we ask of you. Similarly, another program regarding markets and the environment that seems to have worked well, although there are some problems nowadays, is Washington State and the connection between water banks that are local and the Trust Water Right program. So again, human rights, environment, and now I will briefly talk about communities. So what happens when suddenly we need water for urban areas and farmers in a particular region want to sell their water to that community? And this is illustrated, if any of you have watched Chinatown, or if you have kiddos, Rango, by the Owens Valley, which I like to call the original scene of water markets, where LA went to the Owens Valley and with practices that were clearly fraud, convinced farmers to sell their water, and then they siphon it to LA, leaving behind an environmental disaster, but also a community that doesn't have water. And we are still paying the consequences, or California is still paying the consequences of Owens Valley. Right? They have to pay for the environmental restoration. It's unclear how much development the Owens Valley itself can have in the future if you don't have water. Right? So while economists normally refuse to acknowledge this type of effects because they call them pecuniary externalities, and for them, water leaving to a city from a rural area is no different than General Motors relocating from the Midwest to China. And some people believe that that's the case, but even so, water may be different. And it's different because, you may have an economic transition to a different economic activity, but you will always need water. And without water, it's very difficult to plan for the future. And it's not clear to me whether those communities can really buy back the water. And maybe for political reasons, but we have put some mechanisms in order to prevent those community effects. So in some jurisdictions, they have tax transactions in order to compensate the community. In others, they give the community a veto power. In others yet, what they do is they set a limit. You can only sell up to 25% of the water rights in a community, or whatever is the percentage they have assessed at which there is a break-even point, right? If we go over this, the community really suffers. Below that, the community may suffer less because the first water to go is the water that it's marginal, that it's put to certain agricultural uses that are not gonna bring most of the return. And the focus of the rest of the talk will be on speculation, right? Like the bad and the ugly. So I mentioned before, right, when we have a speculation, we imagine trading stocks for a profit. And the closest we have in water is the trading of water futures in the Chicago Mercantile Exchange. There is an index there called the NASDAQ Pérez, let's see if I remember, the NASDAQ Pérez California Water Index. What that index does, and I will go back to this. This is the return on that index if you invest on it. What that index does, it predicts the price of water, and you bet on it. Right? And it's based on 5 very active water markets in California, one of the largest markets. Groundwater basin, 4 adjudicated groundwater basins and the surface area nearby. A lot of people criticize the idea of betting in the price of water, but while I see problems in other Wall Street related water issues, these can be used actually as a shield for the risk of how much you're going to have to pay for water. A little bit like a drought insurance for some farmers. What is slightly more concerning is this whole idea of Wall Street actually buying water rights. If you watch the 2006 Big Short movie, Michael Burry, the main character, who predicted the subprime crisis, at the very end says, and now I am moving to water. And he actually has moved to water. He has bought land in the Columbia River area in order to get access to those water rights. Because water is perceived as a commodity that will only increase in price. So it's a win-win situation for sure, provided the regulatory scheme allows them to do the transactions they have in mind. Speculation has always been frowned upon in prior appropriation. We have the anti-speculation doctrine, or the use it or lose it or forfeiture doctrine. Traditionally, this was understood as the following: nobody should be able to sit on their water rights just waiting to sell them for a profit. You have to put them to use. We think of water as a productive input, not as an investment asset. And that has worked well up until now. Because Wall Street can face that and comply with it, even if they violate the spirit of the law. So let me give you the main example, which is the water asset management. A New York-based company starts buying water in Colorado. It buys water in mostly two mutual districts, the Grand Valley Irrigation Company and the Grand Valley Water Use Association. They buy land when land comes associated with water rights, or they go ahead and buy water shares. In some of these organizations, they are now the main landowner or the main water rights holder. Farmers sell to them because, after a year of a bad crop, they have to pay the mortgage. They offer a good price. The rest of the farmers are not very happy about it. There is actually a wall of shame where farmers comment on each other selling water to these Wall Street outsider types. Why are they investing here? There are two hypotheses. They either want to sell to urban areas in Colorado that are growing and that are likely to need water in the future, or they are waiting until the state of Colorado needs to buy that water. State of Colorado needs to comply with the Colorado River Compact, and for that, it has in the past, and it's likely to do in the very near future, buy water rights from farmers in order to be able to deliver what it needs to the lower part of the Colorado. So how are they complying with the anti-speculation doctrine that I mentioned? The anti-speculation doctrine in Colorado entails that you have to use your water right. If you don't use it for a period, I think it's 5 years, Utah it's 7, it will be canceled by the administration. So they are leasing back that water, sometimes to the same farmers that they have bought the water from. Even if they lease it at a very low price, this is a loss they are willing to face because they know the profits in the future are gonna very much make up for it. So they are complying with the letter of the law, even if they are not complying with the, with the spirit. Colorado started in 2020 with a working group trying to find how they could strengthen their anti-speculation doctrine. The group didn't come up with any unanimous proposal. They played along with the idea of taxing transactions, of not allowing foreign outside of the state entities to invest in water, and others, but nothing really stood out. Nonetheless, it prompted the legislature to actually introduce a bill, and then it was approved this past spring, defining speculation. And they define speculation as, let me see if I can give you the specific, the specific definition that they are using. Yes, purchasing agricultural rights with intent at the time of the purchase to profit from an increase in water price in a subsequent transaction or by receiving payment by a third party, including the government, for not using that water. Right? That's what we understand as speculation in water. The bill allows, or the statute allows, the mutual districts to define which percentage should be a red flag. Once an entity has bought as much water rights as to meet that percentage, they have to go through a review for speculation intent before the state engineer. If they are found to be engaged in speculation, they are fined $10,000, which in my opinion is very low given the type of actors we are thinking. There is also a provision in order to prevent any frivolous claim, because they fear that some of these farmers may attempt to use this provision as a harassment for some actors that they consider not part of the community. I am not sure this is the way to go, because proving intent is always very hard. And I am also not sure we are getting at what is really problematic here, is the combination of this speculation, if you want, with the scale, right? Water asset management is the main right holder, and it's a sort of quasi-monopolist in some of these areas. So they can influence how high the price will go, right? It's almost a hoarding practice. Plus, there are other problems with concentration, particularly when we think about these, some of these irrigation organizations. So in some of these irrigation organizations, it's not one person, one vote. You get as many votes as land you own or as water you own. That means once you have assembled enough of a portfolio, you can dictate many of the rules in that organization, tipping the balance furthermore in your favor. So I do believe thinking about how to deal with concentration may be a better frame when we think about which regulations to put in place when dealing with this type of very large actors that are not engaging in any type of productive activity, but investing in water as a financial or as an investment asset, if you want. And in order to think about this, I believe it's helpful to look at other natural resources. Many of the natural resources in the West have been, or part of the creation of property rights over those resources was the anti-monopoly principle. Think about the homesteading. Think about minerals in federal lands or oil and gas in federal lands. We set up limits on how many of those rights someone could accumulate. We did the same much more recently when we regulated fisheries in Alaska. No, you couldn't accumulate a certain number of a certain number of fishing quotas. So thinking of that may be helpful as to think whether we could just set a limit of how much water someone could accumulate. And it could be a preemptive, right? We are not gonna apply an antitrust framework with only when you do some anti-competitive practice, we react. And funny enough, I have been reading some history on private appropriation, and some historians believe that we missed the point when we started codifying private appropriation, because private appropriation comes from the mining camps. And all the rules in those mining camps had a distributive justice component that somehow was lost when we engaged or when we translated those into private appropriation. So with that, just say that I still believe that while water markets have problems, they are a good tool. And the solution is not to erase them from our water management portfolio, but actually to strengthen them with proper regulation. And with that, I welcome any question or comment that you may have.
So, Vanessa, we do have a couple questions. This is working, right? The mic? Yep, good. One asks, what will it take to have a prior appropriation doctrine be updated to the 21st century, that is to have true market pricing?
Well, first of all, what it will take to update it, whether in a market or in a non-market route, it's a lot, right? Like whatever we decide to change, we are going to change property rights that have existed for centuries. That's always a problem, right? You can get into takings, you can get into just resistance to change, right? California has very old water rights prior to 1873, which have much more protection from administrative agencies having control over them, and they have tried to tweak in the margins and they have been unable. So I'm not sure there is that much, or I am not sure that in the United States we could undertake an overhaul of water rights in the way Australia did. That doesn't mean we should we should assume that nothing is going to change. Things have been changing, right? California seems to have interpreted a combination of beneficial use and reasonable use that appears in their constitution to justify that no matter what, they are going to satisfy domestic uses first. And that seems to be the direction many jurisdictions are going. So I don't think we will ever see, and I don't think we have any good comparative experience either, where all our water allocation is going to be based on a market system. The closest we have come to has been Chile, where what they call the Chicago Boys, right, the whole idea, the Pinochet dictatorship, embraced the idea of free markets. And they took it to the extreme in water, where you could transfer water in the same way that you can transfer shoes. You will agree with someone that you were going to buy their water, no approval was necessary. If there was a conflict, you will go before the civil courts. And that has worked sometimes well, in some basins not so much, right? There is a basin in the north where that implied that many people didn't have access to water. There were indigenous groups that were completely marginalized because of that. And now they are undertaking a water reform that perhaps the mistake there is going in a pendulum way from the from the free market to the completely non-market. I just think that there is a sweet spot where markets will have to play a role in prior appropriation, and maybe we will need to tweak some of the rules, but I don't think the 21st century water law will be water law in the same, Jeff Bezos is not going to be the person telling me whether I can trade water or not.
Second question, is there an antitrust framework that you think should be applied to water markets?
Like any other market, right, we could think about whether certain accumulation of market power leads to practices that are affecting consumers, right? The standard may change. We have new blood in the Federal Trade Commission, so I am still going to use the classical consumer welfare standard. But that tends to be mostly a reactive, right, like an ex post analysis. And I am not sure we want to go there. I think it's more helpful to think prophylactically how we can prevent that concentration of power in water markets to happen.
Before the fact rather than after the fact.
Yeah.
Yes. Can water markets be reasonably expected to induce conservation in domestic consumptive uses?
So it depends. The main thing is none of us, when we receive water in our households, normally have a water right? Like if you have a ranch, you may. But if you live in a more or less urban or suburban setting, you will be receiving water from a water utility. So everything will be, it will depend on the channel of transmission. If that water utility normally receive water at a certain price, but now it's not going to receive enough water or has to serve more customers and needs to buy water in the market, it may need to increase the amount you are paying. If you are going to pay for any good, you are going to think more carefully how much water you are going to use. However, what we have to do, though, is remove barriers for that to happen. And let me give you the example of California. California allows for different tier systems in water tariffs based on the cost of transportation. So not based on scarcity. So when the situation became really dire around 2013, a lot of these water utilities wanted to establish a tariff that will be very steep the more water you were using, because they didn't have enough. But because it was not related to price, because they were not buying water, they simply didn't have enough, they couldn't price scarcity in order to discourage certain uses. So it may, right, like if a market translates into higher prices, provided that, as I presented here, or as I think it's necessary, we protect certain amount of water that we need for basic needs, a higher price will definitely induce us to be much more mindful of how we use water. And maybe people will start not having lawns in Texas where, and it's not exactly a wet area.
That same debate is going on here, for sure.
So funny enough, one of the issues that many Texans are facing is that their homeowners association requires them to have very flashy lawns, even though there is not enough water.
This one asks you to comment on Walton Family Foundation's campaign to establish water markets in the Colorado Basin, and goes on to suggest that they'd distributed money to NGOs, journalists, and universities over the last several years to tilt the policy debate in their favor.
I have heard the rumors. I don't have much information about them, so I have not received any money from them, so my research is not tainted. I am pretty sure that if we dig deeper, a lot of the reforms, like almost anything else, right, could have the influence of interest groups that may have nefarious purposes. My fear, and this is something that we have to think about, is corruption and undue influence are always bad. The problem is that when they happen through a market, they may be shadier, because we tend to think the market as something that works in a decentralized manner. So to the extent that practices are gonna be more difficult to spot, then we should be more worried than we are currently with the same interest groups trying to influence, more, if you want, command and control structure. I am sure that there are interest in water markets. Something I didn't mention when I talk about Washington is that Washington State is also facing the investment from Wall Street. And they have this trust water right program that allows you to bank your water rights as if you were helping the environment, at least for a number of years. And they have instrumentalized that in order to speculate, right? They buy water, put it on the trust program, create a water bank to then transfer that water, right? That's not the purpose of the structure, at least on paper, right? Whether or not it was in place to serve, to sidestep the forfeiture doctrine and to serve some interest, I am not private to this information.
Thank you. If the water that we have saved through collective conservation efforts is just used to build more subdivisions, the questioner says we're actually worse off. So what can a market do to ensure that water saved is kept in the natural system?
So several things that make me think about, or that this question makes me think about. One of my mentors, when I was talking about this project, told me, well, we only call speculators those in suits. If speculators wear boots, we don't care. Right? Because in any event, when you have a water market, a farmer is profiting from a resource that they may have received for free. They may be profiting from the fact that in the past they were using an inefficient irrigation practice. And now that you're letting them have profits by selling that water. And that's true. I do think that the scale matters. And that at the end of the day, a farmer is somewhat more connected to the community. Having said that, this whole idea of our collective effort saves water, and then instead of putting that water for the environment, we're going to allow further subdivisions. So one thought is, why are we allowing those subdivisions, right? We should scrutinize whether there is enough water, or whether instead of a subdivision, you should have, more dense urban areas. And in California, they have asked for quite some time now any developer to justify that they have enough water for the next 30 years. So thinking about the role that water has to play in allowing any new urban development could be helpful. I don't know if the mechanism should be some sort of approval by the water agency, or what else can we do. Certainly, if you ask me from an environmental perspective, suburbs shouldn't exist. We have to deal with the ones we have because we cannot destroy them, but we should be thinking about what is best from a global perspective environmentally. Additionally, not in this idea of collective effort, but in many water banks, particularly in the California ones, and particularly at the beginning of their creation around 1991, you couldn't access water from the water bank unless you prove that you had implemented measures to increase the efficiency of your water use. So you first needed to try to save as much water as possible before you could access the market. And that's not normally how we structure transactions, because we should, the idea is this is voluntary transactions and whatnot, but there is no risk. It's a possibility that we could come up with some ideas on how to, what we would require for a buyer before they can actually get a transaction approved.
We're getting short on time, but here's one with a local twist to it. Utah faces pressure to transfer large amounts of water to save the Great Salt Lake. The 4% amount of water from markets will not be enough. Any thoughts on how to get enough water to save the lake?
Well, I don't have a thought on how to save the lake, but clearly you have to save it. I would say, again, I think markets introduce flexibility. If what you need is it's something that requires a lot of sacrifice, you need command and control, right? You have to come up with a decision of how to save the lake. And that comes at a cost. And it's a cost that at least if I were a resident of Utah, will be willing to face, right, in whatever form. It may be that I have to pay more for the water because we have introduced a cap on the amount of water we can take because the rest has to go to the Great Salt Lake.
Thank you. One more question. This takes us abroad. Australia is piloting a blockchain solution to its current water market with the aim of reducing costs, improving efficiency, and increasing transparency. Does this solution impact any potential problems on the commodification of water?
I am not the right person to ask a blockchain question. I have been trying to fully understand it, and I have come short. I am, however, hesitant about, all these blockchain solutions to democracy and to major problems. And I am even more skeptical in the Australia case, because this is a pilot, and it's almost as if, you are in a bad situation and you double down into what has put you in that bad situation. I don't find you can convince me otherwise, and those who know a lot about it may think my position wrong. I don't see blockchain as transparent, and I don't see it as a good tool to level the playing field. And one of the main critiques of Australian water market, apart from the corruption of paying millions to a mining company from the Minister of Agriculture in order to get their water rights, has been the lack of transparency and the advantage that brokers and other sophisticated actors have over indigenous communities and farmers. So yeah, I'm not sure introducing blockchain will change the scenario. If someone can demonstrate that it is, and that it's going to make it easier for everyone to access the market and to have enough information, then I would definitely welcome it.
Thank you.
Thank you.
Let me simply announce again that next Tuesday, Stegner Center will host a pre-recorded presentation by Brenda Mallory, the chair of the White House Council on Environmental Quality. And next Thursday, we will be hosting here live Emeritus Professor John Leshy speaking about his book on the history of the public lands. And with that, please join me in thanking and recognizing our 18th annual Young Scholar, Professor Vanessa Casado Pérez. Thank you for your presentation today.